We're waiting for Stan. There's Stan. All right.
Hello again. I saw you in San Diego, I think, last year.
Yes, good afternoon, Stan.
Go ahead.
All right, good afternoon. Michael Ignazio, Supervising Inspector with the Board of Pharmacy. Here to present to you just kind of a Cliff Notes version of the FDA published guidance regarding the Drug Supply Chain Security Act. And this is in relation to suspect product and notification. So within this guidance, the FDA kind of outlines what trading partners and manufacturers should do and the process to notify the FDA. And it also presents certain scenarios where suspect product or illegitimate product may enter the supply chain. So this was published last month. So it's fresh off the press. And it involves both manufacturing and trading partners. The manufacturing part that they published in this guidance is specifically only for comments, so that's not to provide any guidance to any manufacturer, but the rest of it is to provide guidance and comment. So starting out with the statutory mandate for the Board of Pharmacy, again, just reiterating that the Board of Pharmacy's utmost is for the protection of the public. And you'll find this in Business and Professions Code 4001.1. And anytime that the FDA publishes any guidance, they always have a disclaimer, making sure that the guidance that is being published is not binding. And it's important to note, too, that the FDA notes that an alternative approach, other than what's specified in the guidance, may be used as long as it satisfies the requirements of the applicable statutes and regulations. So just a little bit of background on the Drug Supply Chain Security Act. So President Obama in November 27, 2013 signed the Drug Quality and Security Act. Again, and this is response mainly towards NECC and the New England compounding issues and events that happened in Massachusetts. From that, two different titles came out, and we have Title I and Title II. Title I being the Compounding Quality Act, and Title II being the Drug Supply Chain Security Act. And within the Drug Supply Chain Security Act, it defines two different types of product, one being suspect and one being illegitimate. Suspect products are the potential without the irrefutable evidence that proves that these products are illegitimate. Illegitimate products are those that have been tested, have been confirmed to be either counterfeit or adulterated. And the requirement is in Section 582 of the FD&C Act, and this is regarding the notification to the FDA and all trading partners once an illegitimate product is determined, and this needs to occur no later than 24 hours. It takes it another step further for manufacturers. With manufacturers, it doesn't only notify for illegitimate products, but also for suspect products. So once a suspect product is identified and brought to the attention of the manufacturer must notify not only the FDA, but all immediate trading partners. And within the Drug Supply Chain Security Act, it outlines critical steps in building an electronic and interoperable system within the next 10 years that will allow for the identification and tracing of prescription drugs as they're distributed within the United States. The scope. So the scope of this particular guidance, as I mentioned at the beginning of the presentation, is to identify specific scenarios where suspect product, illegitimate product may enter the supply chain. In addition to, it provides guidance for manufacturers and also for trading partners within the notification, and it's the use of a Form FDA 3911 that you can find on the FDA website. I have a copy of that at the end of this presentation. And it also provides information on the termination once either a specific suspect product is identified. It allows for notification to terminate that with the FDA, and that's outlined here as well within the presentation. So first is the identification of suspect product. And within the Drug Supply Chain Security Act, it states that all trading partners must have systems in place that enable them to quarantine and promptly conduct an investigation for any suspect product. And once that determination is made, it allows for notification to the FDA. What's interesting here is the trading partners. It says it must have the systems in place, but it doesn't specify what those systems entail. So within those systems, it could be contracts with an outside lab, with a third party to test that drug. It could be a number of different methods to come to determination that that product is illegitimate. But within this guidance, it doesn't outline the specifics for that. So these next 3 slides are regarding specific scenarios that involve trading partners, product sourcing, supply and demand, value of product, and appearance of product, all different scenarios where suspect product, illegitimate product may enter the drug supply chain within the United States. So the first one is regarding trading partners and product sourcing. Different scenarios that may come up where suspect or illegitimate product may enter is purchasing from a new trading partner that the trading partner has not dealt with in the past. Unsolicited offers, such as email, fax, telephone calls from trading partners that are unknown or have never been dealt with in the past. Purchasing on the internet from an unknown source is another potential area where suspect product, illegitimate product may enter the supply chain. And sourcing from a trading partner who is engaged in questionable or suspicious business practices. The next area where illegitimate product, suspect product may enter is in regards to supply and demand and history and value of a specific product. So such medications that are used in HIV therapy, antipsychotics, cancer drugs, those may be counterfeit, adulterated, brought into the supply chain. Also, when a product may be offered at a price that is too good to be true, those are areas where suspect product, illegitimate product may enter the supply chain. And this last scenario is regarding the appearance. So I think the FDA's kind of outline or what their outlook is empowering the licensees to identify, to be proactive in the identification of products that may be suspect or illegitimate. So what they're saying here is that the trading partners should kind of examine the package or container in which that product is shipped in, if it exhibits any unusual or excessive adhesive residues, missing information such as NDC, lot identification, or expiration dates. If it's missing any security technologies such as holograms, color shifting inks, neck bands or watermarks, and if ultimately if the finished dosage form seems suspicious. Really it should be, an investigation should be started. So again, it's strategies for trading partners to identify suspect products. And this section here, the FDA kind of gives kind of guidance on how they should go about identifying suspect products. And the first one is be alerted offers that are for sale or very low prices that are too good to be true. Closely examine the package or transport container that the product comes in. And closely examine the package and labeling on the individual retail unit. With our talks and collaborations with the Department of Public Health, we found that different products, counterfeit, adulterated products, have had NDCs that may be from Canada, maybe from the United States, different types of numbering sequences, and also different languages found on the labeling of the product are all identification of potentially suspect or illegitimate product. The next two slides actually are for regarding the notification of illegitimate products. And it kind of goes as a stepwise approach in the guidance of how trading partners, once an illegitimate product is determined, how to notify the FDA. And the first one is trading partner should access the FDA's website, and within the website is the Form FDA 3911. And this is the form used to report any illegitimate product. Once that form is completed, should submit it to the FDA website. The FDA will then subsequently acknowledge receipt of the notification and assign an incident number. And then in addition to notifying the FDA, once an illegitimate product is determined, the trading partner must notify all other immediate trading partners. And the next slide is regarding the termination. So much like the notification to the FDA for any illegitimate product, this is regarding the termination. So the trading partner must make a notification to the FDA. They'll access the FDA website again, and again, they'll follow the instructions on the 3911 form that's published by the FDA. And the last slide is regarding it's just a small picture or snapshot of what the 3911 form looks like from the FDA that you'll find on the FDA website. That's pretty much it. Do you guys have any questions, any comments?
Do you believe we need to submit comments to the FDA?
I don't believe so, because the guidance itself is just identifying potential scenarios. I think this is based on FDA's investigations that they've done in the past, and they published, and kind of just making sure licensees are aware of different scenarios of where this might happen. And this is a lot of the things that we find from the field as well, was kind of outlined in this documentation too. So
I can't imagine any of our input having a substantial impact on them with regards to their policies.
Do we have an impact on FDA, Ginny?
They actually do talk to us. And in this area, they used to talk to us a great deal when they were just starting to set up. But, when was the 50-state meeting? November? I talked to them as recently as November on what's going on with supply chain security. So, I mean, our role has greatly diminished since we were actively involved. But I agree with Michael's assessment that there's no need for us to really provide comments to this. But one thing I think we do need is to get the gist of this and put it out as a newsletter article so that it goes out to our licensees so that they're aware of it. Not all of our licensees read the FDA website as perhaps they should. So this is one thing that we should be doing.
Script for the next issue of the script.
Yeah, exactly.
You can condense your PowerPoint into an article for us.
Christmas came again, what can we say?
Thank you, Michael.
you're welcome. You're welcome.
Great job. Any public comment?
Steve Gray from Kaiser Permanente. I would suggest you also have this discussion with the medical board and the dental board. Some of the suspect products that we've discovered have been because the physicians noticed
Yeah.
something, and a lot more very expensive, very susceptible to counterfeit and diversion drugs are now administered in the medical offices. And when they don't get the response they expect, that's how we found out from, that we had EPO that was counterfeit, was they didn't get the response. We would have never known about it if the physicians hadn't said, hey, wait a minute, this was a perfect candidate, or these were perfect candidates for this drug, and it didn't work. What's going on here? And I don't know if you remember that, but that was, I got involved in that with an FBI investigation. So I don't think they're aware of it. They may not read the FDA things the way pharmacy people and boards do, so suggestion, maybe they need to put something like that in their newsletters also.
Yeah, maybe if we write the article, we can let them have at it too. So, thank you.
Thank you. All right, moving on to item J, and actually this probably should be under compounding matters, but it is discussion and consideration of beyond use labels in institutional settings. At the last full board meeting that we had in Glendale in December, the board received a request for a modification for the use of the word "do not start after" instead of "exp" for expiration on prescription labels. And this came from Providence Health and Human Services. And they were going to make a change to their EMR, so it's going to involve some programming time and cost. So they wanted to float it by us before they went ahead and made the change. So the problem is that when you do make a sterile compound, the issue is not the expiration, it's more when you can start it, when you can start the drug. So even if it expires, I mean, even if your beyond use date is when you shouldn't initiate the infusion. So they thought it would be clear for the nurses to have the do not start after instead of the EXP. And looking in terms of our Business and Professions Code, Title 16, 1735.1B, we do provide a definition of beyond use date, which is consistent with what Providence is recommending on do not start after. Now, I don't know, now, do we have to, I mean, the only thing I can imagine is why they're floating it by us is because they want to make sure that they're not cited in an inspection for using that.
They can go beyond, as long as they meet the minimum requirements of what has to be on that label, they can add additional components. That would be an addition. And in fact, it's actually already authorized by what the beyond use date says with
So
the
they don't-
date and time.
They don't have to put expiration, they can put do not start after, which is the same thing as do not, as the beyond use date. And we are not going to have an issue with them from the enforcement side?
I'd say the expiration date's already on it, essentially because they've got the date and the time you've got to start the infusion, and already included in that infusion would be the time it took to deliver the medication to the patient. In fact, as they said at the time, it provides clear direction to what's really appropriate for this medication.
See, Christine wants to say something.
I don't think we have legal code to require the term beyond use date on the label. If you look at the labeling requirements in 1735.4, let's see, A4, it says beyond use date of the drug preparation. The words beyond use date are not in quotations, and Laura can correct me if I'm wrong, but if it's in quotations, we expect the actual verbiage on the label, but it's not. So they can use anything that means beyond use date. That's when we would use a 1735.1B interpretation. So I don't think what they're putting on there, the do not start after, is a problem at all.
Yeah,
I
no,
think it's
I
absolutely
think it's
fine.
clearer, actually, for
Yeah,
the
it is.
nurses.
Yeah.
Okay, so we don't have an issue, I don't think we have to take any
I
motion.
don't have a concern based on what I'm familiar with, and I would probably on that issue, unless it specifically required, content like you're saying, it specifically said the label shall contain, and then had quotes, the following language, I probably would simply
Wow.
defer to the pharmacist's expertise to determine whether or not that was consistent.
Well, again, this is another newsletter article, I think, then that way we can appropriately vet it legally to make sure we're.
No, and I think we could encourage it, because I think that's a much clearer
Absolutely.
interpretation for the nurses as well, so
Yeah.
I don't see an issue with it. I don't think we need to take any action.
Okay.
Public comment.
Steve Gray, Kaiser Permanente. Everything comes around again about every 10, 20 years. The board had the same discussion in the outpatient environment probably about 20 years ago when we were rewriting the law, and people wanted to know if they had to use for the outpatient dispense prescription expires on. And it got confusing because there's the manufacturer's expiration date, and then there's good pharmacy practice, which might be a shorter date. So a lot of pharmacies have modified their system, so instead of saying expired on an outpatient drug, they say destroy after. So
Yeah.
it tells the patient. So in your newsletter article, you may want to cover both issues, and because right now, it's not clear, for an example, with all this information out about whether you can destroy drugs or whether the patient should turn them in to a collection site or mail them back. It may be confusing when we're telling patients out there to destroy drugs after a certain date. I don't know if that's the right words. I'm just saying this discussion came up, but in a different practice environment, which was
I think the
outpatient.
focus on this is for institutional.
Right.
Yeah,
So
for
for,
this.
say,
Right.
hospital.
Expiration.
Might want to
Yeah.
cover both. Thank you.
All right, moving on to compounding matters. A, discussion and consideration of statistics for board-issued citations and fines for compounding violations. So Board Member Schad had actually reviewed the 2016 compounding regulation citations.
And I was going to read these to you, but somebody has to get a plane. So,
So this is citations and fines
yeah. So
for the whole year?
this is
11 months.
January 1 to January 1 to December 16th, the 735s, which is 1735, which is compounding, and 1751, which is sterile compounding. All the citations, fines that were given out. And so I divided them up into the two sections. They were mixed because most of the institutions had both compounding and sterile compounding citations. And so I put them, this first sheet here has a descending order of the infractions. It's essentially that with 75 pharmacies had compounding infractions, and 38 pharmacies had sterile compounding infractions, and those 36 of those pharmacies are included in the upper 75 pharmacies. So they had compounding.
Most of them had both.
What?
Had
You're right,
issues
yeah.
with both.
They had both. They had both, and so then I further delineated it as to exactly what.
It's floating around, Christine wants to
Oh yeah,
see it.
there's
Oh,
copies.
it's down over there, sorry.
There were some of what particular letters, what particular sections of the larger sections were cited, and so it's not mistaken. It's not surprising that things that were excuse me. It's not surprising the number of things that were cited, and it's not surprising upon review of the citations exactly what was cited, the quality assurance, the requirements, and the training. But some of the things that I did find somewhat surprising was overall it looked like the pharmacies were not prepared for these inspections. I was shocked at the number of citations. And now, I don't know what this is compared to the number of places that passed and got no citations. And I don't know if there's any type of...
I can answer that. We've got approximately 1,100 sterile compounding pharmacies. So if this is broader than sterile compounding, because the 1735s would have been general pharmacies. So it's, in there we've got 6,500 of those. But if you just use the base of 1,000 in the state, we've got another 100 outside, you can see that it's less than, it's right around 10%.
Well, it says 38 pharmacies, but there were 80 pharmacies that were in here, right? Combination of both.
Right.
Okay.
There were 80, oh, I'm sorry, I was adding the 75 to the 38 and got 120.
Well, he said there's a large crossover between both.
Oh, that have
Right.
both, if they violate one, they violate the other.
Well, right. Okay, so we got 1,000 pharmacies that were...
Sterile compounders.
Okay, and so 90% of them passed? That's absolutely wonderful.
That's how I turn it around, because you've only got really 38 that were cited for sterile violations, which is even lower.
That seems amazing.
Get to work
This
over
is
there,
citation and citation and fine.
Yes.
Wow, only 10%.
That doesn't seem right. I mean, this seems right, but I mean, if there's only 38 of the sterile compounding facilities that we visited out of 1,100,
That we cited out of 1,100. We visited all 1,100 because every year we have to go into each one of them.
But we only found 38 pharmacies for
So
sterile
there's your,
compounding.
yeah.
Wow.
That's really low.
Now, there could have been some violations noted that the citation and
What was
fine
your-
wasn't
what was
yet
your-
issued either.
Date range again?
Pardon?
The date range you pulled data for?
I was given.
January 1st to December 16th.
Any citation issued after January 1, 2016, but before December 11th.
Does that seem right?
We have roughly 300 LSCs that renew on 11/1, so you may not have captured some of those renewals in this period, so that's why the number may be.
But Christine, remember, we started January 1. They would have gotten picked up from the prior year, and they would have been caught in there. Because if we visited them prior to November 1, we wouldn't have been able to cite them until the earliest is probably January. So I would say we picked up the November ones.
So what else did you,
Are you pleased with the outcome and satisfied?
No, I'm not.
That's really low. I
That's
mean,
really
I
low.
agree with,
I
I
can't
agree
believe
with
we're that
Alan.
good. See, I thought we were bad, but
so-
now I can't believe we're this good. I have that same
So
problem at home
what else did
sometimes.
you
I
find, Alan?
I can sympathize with your family.
Yeah, that's relative.
I'm sympathizing with them right now.
Yeah. I'm confused by this.
Well, we will track it over time, and we will pull it a different way and see if we can get a different count of how many pharmacies are actually involved, and whether or not they're pharmacies that don't do sterile compounding or general pharmacies, and we'll try to pull them out a little bit.
Okay, now, the poll that I would like to see would be by institution, by pharmacy, rather than by the 1735s and the 1751.
So you want to see how many, okay, that's the way Christine has traditionally reported the data.
Yeah,
She talks about how many community pharmacies were cited and how many compounding pharmacies.
Yeah, and then how many passed?
And then go to that, you'd find that a better metric for you.
Yeah, I think,
Okay.
and I'd like to see that. Some of the problems I found was that in some of the sterile pharmacies, sterile compounding pharmacies, was that each satellite in the same location, in the same facility, at the same location, would be cited, resulting in multiple fines, essentially for the same transgression. And so, we've got 3 hoods here, we're going to cite it 3 times. That didn't seem right.
That doesn't seem right.
I don't know whether we did
That didn't
that.
occur always, but it occurred every once in
Yeah,
a while.
that doesn't, unless there were 3 separate kinds of components, but each violation should have
It
been
did
one.
did not appear that they were
Okay.
different types of hoods. And also, the same issue came up that there were a couple fines for each hood location. There was no, the training for each was required for each hood location. Now, that didn't seem.
Training for each hood
training for-
location?
Yeah. Oh, yeah. And so I was.
Really?
Yeah, so that only had, well, there was one and another one that kind of looked like that. The degree of intensity of the inspectors seemed to vary by location. And the fines for the same offenses seemed to vary widely. And the natures, and as a matter of fact, as the inspections went over the year, at the beginning of the year, it had a different face than it did at the end of the year. Different things were looked at. I don't know, maybe people got smarter. But anyway, the nature of the inspections seemed to get change over the year. And then also getting a clear picture of the actual offenses was kind of tough, and that's why getting a facility picture might be better, because you've got the LSC, the PIC, and the facility, all 3 of them.
Could have been cited, right, for the
Yeah,
same
yeah.
thing.
And so, now, a couple of the cases, the former PICs were cited. Former PICs were cited. And so I was kind of curious about what led to that. And then also, I wondered that oftentimes a place is in a mess, the PIC comes in, and somebody comes in, and does that PIC get cited, or is there a mitigation or lenience there?
If the violation occurred under the prior PIC, that PIC would be cited. If the violation occurred before someone became PIC, that PIC should not be cited and generally would not be. And in fact, that would be one of the things they'd appeal.
Yeah, but see, I would think, okay, so I come in as a PIC, and there's a variety of sins there, and I haven't had a chance to correct the sins because they're not immediately correctable. I, as the new PIC, would pick up the citations. Perhaps the old PIC would too. And you say I could get out of those by appealing, but it seems like that's unnecessary bureaucratic process. And so I have concern about that occurring to new PICs. And
Okay,
so
well-
I don't know that it has, but it's just something that I
Okay,
saw on that.
Okay, fair enough. I need to see specifics. I
Right.
think it's a little
Well,
hard to respond
that's
generally.
the trouble with these. And
Yeah.
also, I couldn't easily determine the length of time from the inspection to the citation issuance. It appeared there were some very old dates on the left-hand side that seemed like it might even be 5 months in some cases.
I think 5 months is likely.
And so,
From the time we go out to inspect to the time we issue the cite and fine, 5 months is probably about as fast as we're going to be able to do. Because a report has to be written, it's got to go through 2 supervisors, and then the citation and fine's got to be issued. And so if that's happening in 5 months, that's probably about as fast as it's going to occur.
Ellen, would you consider making your recommendations to the president or the vice president and have them go into detail with this and staff at an org development meeting?
hate to put them through that.
Well, I think it's good to have him involved, just because he's gone over, that's a big stack of material. And the fact that he's gone over it is probably better that he review those and make some recommendations.
Yeah, I don't want to put it on somebody else, Stan. It's
No, well, my curiosity is, and perhaps
you can help me with this, Stan.
transparency is very important.
Right.
And so I'm not trying to limit transparency. But these seem to be issues that are more issues regarding staff and staff issues rather than staff and at a public forum, where eventually.
Oh, right, okay.
Eventually
Yeah,
go.
I see,
Well, he can
I'm
summarize
wondering
those,
If
yeah.
org development might be a better place where we do have discussions about issues that,
Well, it might be better if I go to org development.
if you can.
Well, then we become a
Well,
meeting.
we're going to have
Then we
to get,
become, because
Oh,
it's a
then
public
you become a
meeting.
Debbie's gonna have to
right, yeah. Well,
But we
we'll take this in advance.
maybe we could do is, maybe you and Ellen and I can sit down.
Yeah,
with you and
absolutely.
Go over all these.
yeah, let's do that.
And then one thing that I kind of found unfortunate was that in the labeling requirement, in the compounding, magic mouthwash, which we all are, as pharmacists, we're familiar with it. It's a combination of 4 or 5 people that get a mucositis due to chemotherapy or other. And it's a mixture of 3 or 4 things. There's 3 or 4 different formulas. And most of the pharmacies just label it magic mouthwash. Because of the requirements, it says it has to have the generic active ingredients on there. Okay. And so, but it seems like there's tons of documentation in here about that. There was very little danger to the public. It seems like kind of a waste of staff time and a waste of paper and everything else to prolong the documentation of that. So that was kind of bothersome. There were a couple comments about early filling of a dangerous drug, and I wasn't sure exactly what that meant. And then on a personal note, this is this thing that I hate particularly vehemently, is 2 cases of compounding where pharmacies were compounding commercially available product. And now the reason that I don't like this is that in the case one, the compounding, this one was hydroprogesterone in oil, which used to be, before 2014, a $10 drug, and it now costs $1,500 a dose, and makes it $30,000 per pregnancy. So depending on your insurance, it's just an ugly deal. The next one was an Alapil suspension, and it used to cost $15, and now that it's a commercial product, it costs $300. And it is a separate issue, but I wish something could be done about this within our state regulations. I think we sent in a comment to the FDA regarding that we didn't really embrace that.
Do we find pharmacies for making those?
Yes, we did. And so I think they were
Not enough.
it's like an Alapil. You just grind up one pill and put it in. Been done for years, but now there's a commercial product available, costs $300, $40 to $50 a dose for people, and do the donut hole again. And so, I think that's almost immoral. But anyway, I would we can discuss these these later. I think in the I thought that as a board member, I hear lots of complaints from people that are inspected. But then I see these numbers here. If only, 38 to 75 pharmacies have been cited, and I hear the complaints, I'm a little bit confused by the numbers and the complaints.
We'll probably validate those, and we can maybe go over some of the trends
Yeah.
and sit down with you and go over.
That's fine.
I'd like to hear more in details about
Yeah.
those as well.
So,
But again, the complaints need to come to me too, because nothing gets done if it goes to you, because you guys cannot investigate. That needs to
Well,
come.
he's going to say, he gets the complaints, he's going to say, hey, what are you complaining about? There's not very many people there.
Well, as long as you say that,
Like, get excited.
but regardless of what he says, I mean, really, if something's going to be done about it, it needs to come to me.
well, that's true. That's true. But I don't think it should be true. I think there should be some. I think there should be some other venue that PICs can bring their appeals forward without feeling that they're going to be further victimized. And and that is the true feeling out there. That's why you don't hear enough complaints. And
Well, they have options in the law. They have the right to appeal to an office conference. They have the right to avoid that and go straight to a hearing with an ALJ if they think that they've been victimized by the board. And I feel real strongly, I mean, to me.
But see, this is a case of making the victim responsible. The victim is the perpetrator of the broken law, but they also feel as a victim, and they feel like they cannot bring their case out in the open. And so I think that something should be done to allow a greater degree of representation from the PICs out there. I have concerns that we're going to drive the good PICs out of the business.
Well, that's never our intention to do that.
So I want to touch on a couple things because I understand where you're coming from, but what I hear is something that could lead to a potential violation. And if it's only one particular board member, then we can handle that on an individual basis by having that person pulled out. But all of what you're talking about has the potential to result in a decision that would come to the board as an enforcement matter.
I think these are closed cases, though.
I understand that, but to the extent that you're talking about
Those are not.
new complaints
Oh,
coming
new
in.
complaints. Oh, I got it. I thought you were talking about the report.
If somebody comes to you to complain and there is simultaneously, and this is one of those divides, the executive officer is the complainant in enforcement matters, and the board itself acts as the judges, the final judges. She's the district attorney, and you're the judges. And so when there's involvement that overlaps during that investigative stage or fact-finding, and if board members become familiar with the underlying facts, or they get what we call ex parte communications about a matter, then we recommend that you withdraw
Oh,
from
certainly.
that
Certainly.
if it
Oh,
comes
yeah.
down
Yeah.
the line.
Oh, yeah.
So I think, and it's a fine line of, you want to be part of the process, but also you don't want to, if everybody does it, then you end up becoming out of the process and there's not a body left.
Yes,
right?
that's exactly true, and that's why I would like to see some venue that the PICs feel safe about bringing things forward.
So there is an appeal process built in. I think Ginny was talking about the one, which is the office conference, and then there's the formal process. I don't know if that's what you're talking about. Or
No,
you
well,
want
see,
another-
no, I would like to see something that is a little less threatening. An office conference to someone that is in charge of a hospital or a pharmacy is pretty darn threatening.
It's pretty what?
Threatening. It's very intimidating.
Now, Laura, what if the forum was to them to discuss an issue, not necessarily a citation, but I'd like to know how the board is enforcing X, and I have a concern on how the board is enforcing this particular area because of this. If it's not involving a specific citation or pending matter, would Alan's idea about a forum be a bad one?
forum, is that what you're saying?
Yeah, I think that's what he's
No,
referring to.
In a way.
Tell me more what you're talking about, because it
Well,
does.
maybe we, I want to continue this discussion, but I think we're going to take up time and
Okay.
not make much progress.
Okay.
So let me think about articulating it a little more succinctly.
Sure.
And then we can go on from there at a later time.
Just to kind of finish the loop, because you got a couple new board members. So if a citation is issued, there are appeal rights with that citation. There's sort of an informal level of review to the person who issued the citation to say, could you look at this again? I don't think it's right. And that's the informal conference, office conference, I think, that you hear referred to a lot. The next level of review, if a person's dissatisfied, is they can appeal it to a full APA hearing, So even though the level of action that's taken, it's technically not discipline. A citation and fine is more along the lines of a traffic ticket. It's not, it's an enforcement proceeding from a regulatory body, but it's not a so in our world, we draw that distinction between two types of a citation and fine versus actual discipline. Actual discipline is a public approval, and it can go all the way up to actual revocation of the license. A citation is just the equivalent of basically being a speeding ticket or a parking ticket, where you fine and you're done. And there's a provision within the law that says that. But that being said, a citation is appealable to the Office of Administrative Hearing, and the full process can happen the same way it does for discipline. So it's assigned to an ALJ. There's an opportunity for everybody to bring in witnesses and call witnesses, and then the ALJ will write a proposed decision. That will go to the board members for review. So you don't see a lot of those, I don't think, but you do see some of those, and so there is that opportunity, and that would not, the executive officer would be represented in the hearing just like now by the Deputy Attorney General office through a deputy. Then you would get a proposed decision from OAH, the Office of Administrative Hearings, and an ALJ. So that's kind of the other side, and it's in that context that if there was overlap between a board member and one of the individuals, that we would suggest that you recuse yourself. So that's kind of just closing that loop of where that fits in.
Right.
Okay.
No, I appreciate you mentioning that, and I can it's not, that was not my intention or an unconscious reveal, but nonetheless, I see why you said that. And to your point, Jenny, while you know many PICs, usually it's the PICs that have made an effort to get to know you, and those that are a little more confident than the majority of PICs out there. And so it's a misrepresentative group of people, because most of them are doing things right that know you. And so there's a degree of those that are intimidated by the power of the board. And I've noticed that because a lot of people shy away from certain conversations with me.
Well,
Different
but,
issue now.
but,
Oh,
and it doesn't,
I understand that.
to those of you that are in the room, those of you that know me know it doesn't make any difference to me whether I know you or not. I mean, it truly doesn't. It truly doesn't. So, but there are 6,500 community pharmacies out there, so we've got at least that many PICs. No, I don't know anywhere near that number of people. But I do try to make myself approachable and available. And that's part of my job, and I try very hard to do that. And so I can't help how people feel about me, but I try to be open and honest, and I'll tell you what I think. And so, like I said, and if this is, again, an evaluation of me, it's a little different than if it's just the institution itself and that they
It's an
don't.
evaluation of the institution.
Okay, because it felt pretty personal there for a moment.
Well,
But
as a person in charge, but it's not. I mean, there's going to be somebody in your position.
yeah,
And so what I'm saying is that that for those people in charges of pharmacy, problems with venue that is non. While you say we have well, Laura says we have an appeal process. I don't feel that people will. Thank you very much. I don't feel like people will take advantage of that process. And so those are concerns, and these are concerns in the enforcement section. This is, this conversation is coming up because this is enforcement.
But generally, every month, we have 2 days a month where we spend doing office conferences where anyone that wants to appeal a citation, even though they aren't disciplined, as Laura indicated, have the opportunity to come in and discuss informally. Sometimes they bring attorneys, but they don't need to, and it's an opportunity to do that. The other alternative is that if you want to talk about the way the board's inspectors are handling particular elements, one of the things we could do is put some of those issues on the agenda, like magic mouthwash. How do you want to treat failure to appropriately list the directions, which is probably more or less how it's charged? And bring those issues forward, and that's how the board can become involved in evolving policy.
Yeah, and I think it's important. I mean, looking at the board doesn't really see a lot of the citation and fines, but looking at some of the trends that are coming out may allow us to do education, focus some script articles, looking at ways that we need to look at our regulations, just some of the looking at what's happening out there. And I don't think a lot of times the board knows what's happening on the citation
Well,
and
and
fines.
that's part of what we're doing, particularly in the area of compounding, because ever since we've really started regulating the sterile compounders, we have spent a portion of these meetings providing summaries of what citations and fines that we've provided by category and by license type. So, but if we need to drill deeper, or if there's a different approach you want to try, let's go for it.
Okay, well,
We'll
thank
sit down and go over that
Yeah.
with Jenny. Okay. Thanks, Alan. Item B, or let's public comment. Yes, sorry. Good afternoon.
Afternoon, Jenny Partridge. And I feel very anxious right now because of what I need to say, because you are powerful. So I feel a little scared right now. I'm a consultant. I've been in pharmacy for 30 years. I usually don't say that because it makes me old, but I have lots of experience and wisdom. I'm also a probation consultant for at least a half a dozen pharmacies. As a PCAB surveyor, I guess my point is I see about 100 pharmacies a year. I overlap with your inspectors. I talk to the PICs. There's 2 points here, and I agree with Alan on both of these. The first point is the public, is some sort of forum. Am I shaking? I feel shaky because I feel like
No, don't be nervous.
and it's not you, Ginny, and it's not necessarily the inspectors. It's the feeling of the Board of Pharmacy that the pharmacists, staff pharmacists are afraid. Nobody wants to be a PIC, and they're afraid to speak up, and they don't feel like they can they don't want to come to an office conference because they're afraid they're going to get in more trouble. And so I feel like it'd be really valuable, and I don't know what the forum is. I think of the term ombudsman. Is there somewhere, and I also appreciate having spoken with Christine, you guys need specifics. So I can't call you up and say, Ginny, this inspector was wrong and did this, and this is not what the law says, and they cited this, and I can't do that because you want specifics, and I want to keep that anonymous. And so if you have aggregate data about the way perhaps there's I'm afraid to say it, but there's a condescending, antagonistic attitude of many inspectors. And to Alan's point, there's a lot of really good pharmacists out there. So that's the one thing. If there could be some sort of forum that people could, it not be an office conference or a hearing. By then, it's a little too late, but something where you then, as as the board, you can look at aggregate data. You know, if you hear something once, you know what, that's that pharmacy and that PIC, and there's a problem there. If you hear something 100 times, then maybe there's an overall issue that can be addressed. I worked in the pharmaceutical industry for 20 years with Eli Lilly and J&J. We used to have something called 360-degree reviews, and I hated them, but, you know, because it's your subordinates telling you about how you are. You know, how wonderful for you to get information on your inspectors, because that's how everybody gets better. People, the public is safer, and the pharmacists are better, and your inspectors are better. So that's the one thing on the form.
Can I ask you just a question on that? I know that one of the things we've instituted is that the supervising inspectors are reaching out to inspectees and asking them about the experience. Have you gotten any feedback on that?
I've never heard that once.
Well-
I can tell you, there are most of the supervising inspectors, you know, I don't always know, but the two that I interact with are wonderful, and I can give them feedback. I can privately give them feedback. But I can tell you the pharmacies will not do it for fear of retribution. I mean, I had somebody where I said, that is not what the law says. You need to call up the supervising inspector and help them understand the inspector doesn't understand the interpretation. They said, are you kidding me? I'm just going to pay the fine and move on. I said, but it's wrong.
Exactly, and they need to call me on those because I'm removed from the
They're afraid to,
investigation.
Ginny.
Pardon me?
They're afraid to.
Well, things won't change sometimes. And again, one of the things is Dr. Gutierrez says, we are surveying post-inspection. And those comments are going directly to the supervising inspectors, and fewer than 5% even disagree
That's
with any of the
wonderful.
evaluation of what we're talking about. So if you look at the data, and we have like, what, 160
Yeah,
people?
I looked at them. They're actually not that bad.
It was fewer than 5% had any negative comment at all. And I mean, I don't.
Maybe encourage the pharmacist to be more open with the supervising inspector when they get called, because the whole purpose of that is to get the feedback to Jenny
Right.
and to the board to know what's happening out there.
So,
And that includes badge-heavy inspectors. If we have them, we need to know about it, because that is not, they don't need to walk in and terrorize a pharmacy. That is inappropriate. And they will
I've
be.
stood in the background and watched it about 2 months ago.
Then let's come have a
inspect-
talk.
Yes, okay. The second thing, the other issue, and I'm
wait,
sorry
I
to
think-
take so much.
I want to kind of tie us back. So the topic that we're on is the compounding and discussion and consideration of the statistics for the board issued citations and fines and compounding violations. So to the extent that the comments are tied to those citations and fines and the statistics, let's
Okay.
try to
So I'll bring it
focus
back to
that
the second
in.
issue. Thank you, Laura. I'll bring it back to the second issue. You talked about the magic mouthwash. What we very much need, and I don't know if you guys can do it, I feel like it was done years ago, but I don't see it so much anymore, is somebody to issue an interpretation. So, for example, you might have one inspector that says, okay, you didn't use the specific ingredients on magic mouthwash. Okay, you might have somebody else that lets that slide. And so it's interpretation. And right now, if you call the board, either on the phone or email, what you will get back is contact a lawyer. We can't give advice.
Can't give legal advice, but
If you
that's.
can give an interpretation, what are you telling your inspectors? Because it,
They should be able to answer the question about magic mouthwash and telling you the ingredients need to be listed. That's part of what the duty inspectors do. And that,
the duty inspectors send an email back that I've seen about half a dozen that says, sorry, that's the law, I can't. So how do we know? I mean,
what they would do is cite, Jenny, they'd give you a list. This is the code section that asks you to
That's
list the
right.
ingredients. That's what they tell you. And then, does that mean that I can say this instead of this? They may or may not actually connect that dot. They leave it to the professional judgment of the pharmacist, but they give you the code section that addresses a specific issue. But we get asked a lot of questions, and sometimes they want us to do the legal analysis for them. Frequently, we get a corps of attorneys that are sending us those things.
I see.
And so we're trying to balance the need of the pharmacist.
And I don't know if that's something you have those supervising inspectors do, but I mean, and I'm not going to take the time, but I could give a half a dozen examples where the law says this, and it's interpreted differently by different inspectors.
Those need to come to me.
Okay, terrific.
Well, could you, I mean, since you can maybe talk anonymously for them if there's issues that you keep seeing over and over since you're following the inspectors? Is it something that you can communicate with Jenny when you see those things?
I'd be happy to if you're okay with anonymous.
Absolutely.
I'm so sweating right now.
Take off your jacket then. But
It would help
seriously,
us
just pick up the
improve the
phone and call me.
process.
Okay.
So from the, kind of going back to the agenda.
Okay,
So I think what you have is, based on member Shad's analysis, he's going to have a conversation about the citations. And I see the, the potential for identifying those trends and maybe addressing specific issues that are
Yes.
being.
Thank you, Laura, for getting us back on track.
Yeah.
That
Thank you.
opportunity.
Public comment.
Joe Grisella, University Compounding Pharmacy. I'd like to thank Alan here for bringing the subject up. I think an ombudsman should be there. I think people are very afraid of the Board of Pharmacy. And in my particular case, I was not judged, or I never once spoke with a pharmacist. And it was amazing to me that I went through this whole process and never had a chance to explain it or speak with a pharmacist. And my license was revoked and placed on probation. And I would love to have at least had a chance to talk in front of the Board of Pharmacy, to talk to a pharmacist, to see my point of view. But I think if you people were on this side of the table and were placed on probation, and you had no chance to even discuss this with the Board of Pharmacy, with pharmacists, I think it's it's really sad. It really is. I also think too, in regards to the future, I think this board is more of fine, cite, and fine, cite and fine. I think it should be cite, educate, correct, then make them accountable. You come back in next year, if, first of all, you cite them, tell them what's wrong, then you say you got 14 days to correct this, you correct it. If it's not to your satisfaction, you go back there, but it is to your satisfaction, and then at that point, next year, you come back in and you take a look, was that corrected? I think now it's like cite, fine, forget about it. And I don't even know if you don't even know if it's corrected. So I think there's a little, I don't know, I just think it should be more of an education process. All you people are pharmacists, or many of you are. I bet all of you could not get 100% on the law test. When you take the board exam, what did you have to get? 75%? Is it still that? So that means 1 in 4 are wrong. So it's very hard to know every single law, everywhere, all times, all states, all enforcement agencies. It's not easy. It really isn't easy.
No, we know that. There's a lot out there.
So have mercy on some of these people.
Thank you. Any other public comment? Okay, we'll go on. Christine.
Yeah, timing's perfect, Christy.
We're going to discuss the compounding waivers, construction waivers. During this portion of the meeting, Supervising Inspector Christina Costa will provide an update on the number of requests for construction waivers received, granted, and denied since the October 2016 board meeting. Alan and I and Christine and Jenny and Julie have been spending some time going over a lot of the construction waivers that have been received. As you may recall, January 1st is the deadline when the new regs go into effect. So if there's any construction requests, the pharmacies have to submit them to a special email address, and they were supposed to submit them before December 31st. So Christine's going to give us an overview on what we've received and how many are still pending. Oh, we've had Oshpod help as well. Yeah, Oshpod's been really helpful.
Oshpod is hanging out with us too. So as of the 2nd, we've received 493 waiver requests. We have processed 214 of them, which is 43%. Of the 214 processed, about 50 of them, or 23%, didn't have an LSC, so the waiver was not related to sterile compounding. Of the processed ones, 70 have been approved. 2 have been denied. Of the processed, the 214 that were processed, 112 of them, or 52%, were for a pharmacy, and 102, or 48%, were for a hospital. Currently, in the inbox, waiting for me, are 280 additional ones that we
Well, tell me how many you got on December.
Oh, no, that's the next slide. Let me scan
Oh,
down.
really? You're still
Oh, it's
gonna go over that?
amazing. Okay. So, by received date. So if you look, the first one we received is actually before we even had the process in place on 9/30, but we had it, I processed it. So you'll see the dates in which we received them. Hold on, let me get rid of that thing.
What were the reasons for the denials?
So the one in-state denial was to a hospital, and it was denied because they had no plan. They provided us, basically, they would like a waiver to continue compounding how they are until I believe it was 2020.
Yeah.
And it was a denial.
I
We
think-
needed a plan.
Right.
Greg, some of what's happening is they're just not making good faith efforts. They're basically just saying, we can't comply right now. There's one that said that, I mean, I don't think it was a denial, but it was a pending one, where they said, we haven't really decided what we're going to do yet, whether we were going to remain in this business. So it's those type of things, I think, that
Right.
are leading to the concerns and the denials.
Yeah, so if you look, it got quite busy while I was on vacation last week. We received 70 different waiver requests on the 29th. And it looks like we've received probably 10 today. So it's just going to keep going. So as of when I came back yesterday, these are the ones that are not processed. I will get through them, but what I'm finding as I process them is that most of them are not complete. Many of them are just checking the box, and they're asking for a waiver for all of 1735.6 or all of 1751.4, which is all of the building requirements for a compounding facility, and that's not within the scope of what we're allowed to give a waiver for. I would say probably 90% of the waivers that I review, I have to ask for additional information. Most of the time, it's the code. I need them to provide me the subsection in which they want a waiver for.
They're also asking you for exemptions or waivers for things that are not construction related.
Absolutely, yeah. People are asking for construction waivers for a definition. They're asking for just everything. Most of the time, it's a definition. So right now, the only thing that we can really truly look at is for construction. So that's really 1735.6, 1751.4, and then you need to provide me the subsections. Within those categories, within those codes, there are subsections that are not building related. I cannot give you a waiver for not complying with your policies and procedures. Cannot give you a waiver for not cleaning your facility. It has to be something construction related. The first thing you'll notice is that it says we've processed 214, but only approved or denied 72. All the rest of them, I am in the process of communicating back and forth until I get enough information that I can bring it to the committee for either approval or denial. My goal is to get everybody to where we can approve them so they can continue to practice. But the problem is if they don't have an actual plan, we'll never be able to approve it. If you're going to ask for, we're not going to do anything till 2020, and you don't have any other plan, I can't work my way around that to get you approvable. So that's why there's such a discrepancy between basically the 72 with an end solution and all the other ones.
And generally, the other thing, too, that we've done in the committee is that since some of the construction plans are open-ended, as you know, if you do any construction, you really don't know when your last end date's going to be. We're doing the 12-month, or actually till the end of 2017, so they can go ahead and renew at the end of 2017 if they still need a second waiver.
What do you do about the ones that they're renting their facility? The landlord will not allow them to do the construction, and they're stuck in a lease for another 2 or 3 years. And their plan is to move when the lease is ended and to go into a facility where they can do the construction. Are we going to be denying their ability to compound in this 2 or 3 year period?
Neither of those are the two that we've denied. We do have facilities in that scenario. We've approved a few where their plan within the next 12 months is to actually move to a compliant facility. We've allowed them to continue under the waiver. If the plan is not to move for a couple years, we've asked them for additional information, and they're going to fall into that category that's still pending. What are you going to do? Are you going to put in some type of containment unit? Can you build something and then it just won't be externally vented? Give me other options to allow you to continue to practice. It's not, as much as I would like to just be like, nope, you didn't give it to me, denied. That's not what we're doing. We're trying to help them to facilitate, to allow them to continue to practice like you asked us to do. It's taking a lot of back and forth. Many people don't really understand what the waiver is for. They also didn't complete the form. They're not answering their emails. They're not picking up their phones. It's a very labor-intensive process. I think we'll probably be doing this till at least the beginning of next month.
Sometimes they just need put in another additional equipment, and I think that's the other thing that Christine's identified is recommended to them. Look, maybe this is, so there's some education, and I have to say, just from my participating in the committee, there's been a lot of work that Christine's done on this in terms of advising the pharmacies, giving them guidance on what they can and can't do. I think you've probably talked to all of them on the phone at some point on how to finish these waivers. So I think she's going above and beyond what she needs to do to get these done, just to make sure that we get through this process.
Degree of understanding from each of these applicants is really obvious. There's some that are very sophisticated, there's some that are clueless, and then there's a couple that they're just going to clean out their garage. It's very, the back room. Yeah. But they do need constant reinforcement from Christine to tell them what to do. So it is a laborious process.
Well, and I'm trying not to provide consultation. I'm
Right.
trying not to tell them how to fix their problem. What I'm trying to do is ask them what their facility looks like, what they're actually doing, and then providing, okay, you need to read 1735.6, and then possibly within that section, you'll find the codes that your facility may not be in compliance with. And then, hours on the phone, sometimes back and forth, because they don't really understand. I've had a few very, very angry individuals because I won't tell them exactly how to fill out the form, but I'm sorry, I'm not going to do that. I feel like that's their professional responsibility. If they can't figure out, even with my assistance, how to come over this hurdle, then maybe it's time to stay on the other side of the hurdle. I'm honestly spending way more time than I want on this, but we'll get there.
So
Who have been denied?
in our view, are we being,
Yeah, correct. In the two situations, I think that there was not much we were going to do to come to an agreement that the plan that they had any patient safety involved.
so as an agency, are we being understanding and sympathetic? And I don't know what willing to help means if we're just telling them this is where you go in the law book to find your answer. And what's going to happen with all those who are in limbo, if you will? Change in supply of the product that they put out to California. How is the consumer going to be affected if there's what did you say, about a third that aren't going to currently are either being denied or not getting a waiver?
We've only denied 2, Stan.
But you said that there were some in limbo and.
Well, yeah, there's some that I'm still waiting for them to provide me either an actual plan or a date in which they will be compliant. The code only allows us to provide a waiver, 1 for construction, 2 for a specific code, and 3 for a time frame. If they can't at minimum provide me those 3 things, then I can't bring them to the committee. Well, I guess I could, but then they would automatically be deniable because they don't meet the scope. So that's why they're kind of still sitting there, because I'm going back and forth with them, asking them for this information, rather than just denying them and moving on.
Some of the follow-up that Christine's had to do is we'll get a waiver request where they quote a section that we really can't waive, and then they'll request until 2020 to before they solve the problem. They don't state how they're going to solve the problem. They just want basically a delay in implementation for 3 years, which is problematic.
I've got waiver requests for Title 22. I've got waiver requests for USP 800, 797, it's a broad understanding.
But that may be that they don't understand or they're hesitant to commit to this too. But the regulations now are in effect, and the board spent a long time deliberating these. It really took us 3 years to get to this point. And so what we're doing now and what we've been doing for the last year is educational compliance to try to, when we go into a pharmacy, when the regs change, this is what we're going to need you to do. And not everybody has either embraced that or maybe they got a substandard inspection, heck, I don't know.
And if
But-
they're compounding, Stan, they really should know these regulations. I mean, it's in public protection to know what the regulations are and understand them. There's a lot that, and if the pharmacy, I mean, from my, and I know, Ellen, you can probably chime in, but from my participation there, if they're showing a good faith effort to get there, we're approving the waiver. It's just those that basically said, I'm not going to do it, or they're not clear, or you can call them kind of incomplete applications. And Christine's working with them to try to bridge that gap. And a lot of times, I think she's making some very good recommendations.
I think your concerns are taken care of.
Okay, good.
Yeah.
I think, aren't there also, for temporary purposes, like outfitted trailers that people can use?
There aren't a lot of
Some of the pharmacies are actually asking if they can, if the board will actually license a location that's a temporary trailer, and I think Christine's responded to those.
Yes, we actually have one application already pending for one.
Okay.
It's just getting through the process of getting the trailer actually into California. So we should be getting various assortment. There's a couple organizations that are actually looking at that as their temporary solution to building sterile facilities.
Body?
I think we're just giving an update on where we are and the fact. I did want to ask you a question because I know this keeps, and I just want to dispel a rumor that's out there that we're basically telling, if the facility can't handle the air exchanges per hour, that we're telling them on the hazardous that they have to do 12-hour BUD. And I just want to dispel that because I keep hearing that over and over and over again.
Air changes per hour don't define the beyond use date. The air changes per hour are only really related to the removal of, in most cases, the hazardous drug.
Correct.
And your room in which a sterile hazardous drug is compounded will define the BUD. So if it's a segregated, meaning you only have that room and you have your unit and you don't have the air changes, you're automatically going to get 12 hours. But if you don't have the 12 hours, if you don't have the air changes per hour, then you would need a waiver to continue to compound. But if you have a PEC that's ISO 5, you have a room that's ISO 7, you have an ante-room that's ISO 7, then you can have full BUDs. The air changes per hour, if you don't have that, then that's what the waiver process would be. So then you wouldn't be fully compliant, but your BUD would still be allowed. So there's a difference.
Right, okay. I just wanted to mention that publicly so we can dispel this rumor once and for all that I keep hearing the Board of Pharmacy inspectors are saying, no, let's dispel it.
There's a lot going on in the regulations, and there's a lot of people reading one section and not reading everything in its entirety. And truly, most of the inspectors are coming back with questions at this point. A lot of the questions that are coming in for the duty inspector are running through me because we're trying to be very, very consistent with what we're doing. The inspectors have had hours and hours of training, and I mean, I really think that we're trying to be all on the same page with this, so.
Okay. Any board member comments? Any public comment? Oh boy, everybody's
Wow.
standing up.
All right.
Wow, okay.
This guy's been
One at a
waiting.
time.
This guy's been waiting.
Good afternoon.
Hi. Hi, my name is John Richards with Professional Village Pharmacy. We're a non-sterile compounding pharmacy here in Sacramento. We actually received our waiver. I was one of the ones that put in for like the first date, but I was wondering if there were ability to extend a waiver. I'm running into issues with the landlord that we have, and then also the gentleman I've been dealing with the company that we're with. Oh, I had, I've sent him emails and voicemails. Oh, I had my knee replaced. I'm so sorry. We'll have to get back together after the first of the year. Can you give me a video of the room? I know we were out there and measured it, but I got this, I got that. So I've tried to getting a hold of other people, other companies that do. Oh, we're just so swamped right. I'm calling Colorado. There's no, we can't. I mean, this
One
is
of
the
the things
business
I
to be into
would
right now.
recommend is reach out to their email address. I know
Right.
Christine monitors those very carefully. She does receive a lot of requests similar
Christine
to
does
that.
a great job, but I've called in on the Tuesdays and Thursdays as well, asked the inspector. I've had inspector, because we have available to us, we're in a big, long strip mall, we have another room available to us, so I said, do I have to get a different license for that different room if we're not, completely connected? Oh, that's a licensing question. I'll send you over to licensing. So I talked to licensing, they say, no, that's an inspection
No,
question. You have to speak with the inspector. So I've left messages on both voicemails and never got a call back from either one of them. So I feel like I'm just
Yeah.
spinning in circles. I want to do the right thing. I want to get it all taken care of. I just
So
don't know
Christine,
what
can
to do.
you just email you on try to get this resolved?
And I have Christine's email. I've
If he
dealt
does it through
with
compounding,
before
he'll get it.
and-
You'll get through the
Yeah.
email, through that
The
general
compound.
I'll
email.
get back to you in February. I've got 280 in
Yeah,
front of
yeah,
you.
yeah. No, you're
that's
right.
fine. Just email
Absolutely.
me.
Yeah. Okay. All right. Thank you.
Yeah, the duty inspector line probably isn't the best place to go with that, because really, you're looking at Christine as the main point of contact.
Sure, and I threw her name out there and it said, I've talked to her a couple of times at different meetings, and they just went, yeah, that's their meeting.
And
That's their
what's the
job.
email
That's their job."
address, Christine, that they should be using?
Compounding.waivers with an S at dca.ca.gov.
Thank you. Thank you. Good afternoon, BJ.
Back.
Happy New Year.
The chair won't
BJ
move,
Yeah,
apparently.
exactly. BJ Bartleson from the California Hospital Association. And I just want to make sure I have numbers right, and then I'm going to offer a suggestion. So 102 hospitals so far, right, Christine? That's what I heard. And there's a whole nother bunch of stuff, and I bet there's another 102 hospitals in there probably.
I'm guessing more.
Yeah, I'm guessing more too. Okay, and then one hospital right now that was really defunct, no plan, kind of.
Right. Only one's been
denied. Okay. So we have all the stakeholders, Board of Pharmacy, CSHP, California Hospital Association, you name it, CDPH, we've all worked on sterile compounding tools and education, and we were sort of thinking about education for the hospitals relative to this waiver process. Because remember, at our last meeting, we talked about, we're all still trying to figure it out. So I think the work at hand for you is enormous. I think we could probably facilitate some type of education webinar with you relative to our hospitals. I don't know how we could parcel out now because you have all the applications, but for you to call another, I bet you there's 200 hospitals in there. But these things that you mentioned, the code, the time frame, the OSHPOD, I think we've got some of the basics down. But the interventions relative to, what do we do? Do we get a mobile unit? Can we use another office? I think part of the licensing and certification, maybe there are specific topics and we could do a webinar, get back to the hospitals and support your work so that we can get through it faster. So I'll leave that open. We have a meeting next week. We can certainly, parcel it out there. But-
Maybe if there's big issues that Christine's identifying. I mean,
Yeah.
I think Jenny and I've talked about this, but it's better to have her really working on this because there's so much to do.
Yeah,
But if she's
I can't
identifying
imagine.
specific issues, maybe we could communicate that.
Yeah.
And Jenny, maybe she could let you know on things that we really need, and then we can communicate that to
And I think that's
CHA.
what we were planning to do, is what practices are happening and what's not happening, and how can we identify those topics, and how can I get back to the hospitals with, hey, you're going to get something come back to you because
Mm-hmm.
here's what's not being addressed, here's what you need to do. So,
Yeah.
however we can help you.
Thank you. There are several, and I wanted to mention this. There are some of the hospital chains in California that have been very good about submitting all of their waiver requests. They're doing and they've done a great job. There's still some that are missing, and probably not as good of a job, but there's some that have done a great job.
Well, some of you edited it and made it hard. Excel doesn't cut and paste if you add extra columns.
I know.
Yes.
Good afternoon.
Good afternoon. My name is Washington Osira.
I'm sorry, what's your name?
Washington Osira.
What?
Washington.
Washington Osira?
Good
Okay.
enough, yes.
Yes.
And I work for Neozin. It's a regulatory affairs quality systems consulting firm. And I'm helping a compounding pharmacy out of the Bay Area navigate this transition. I guess my question to you, Christine, is is it possible to have a template of what the ideal waiver request package looks like, including sample letter?
There's a waiver form on the website. If you go to the website, you'll see the sample forms.
Yes, I've seen the sample form, but I'm talking about basically an actual package with a letter that actually spells out what you're looking for.
I think the application is what that is. You just need to fill out that you can follow the guidelines. I mean, it's not required, but it's just a sample that you can use. And the application, if you answer that, it'll guide you through what to respond, what regulations you're asking for a waiver, what your timelines are. All of those things are part of the form.
But I'm also hearing that there are a lot of permutations of what that interpretation looks like, correct?
No, I would agree. I think everybody's interpreting it however they choose to just fill in the blank.
Correct.
So, I mean, there is no one form I can give you because everybody's practice is so distinctly. So, I mean, like I said previously, we need code. I need you to tell me the subsection of the code. You need to make sure it's construction related.
Correct.
I need, at minimum, an end date of your construction. A start date is wonderful, but telling me it's 12 weeks but with no date involved, it's not a complete application.
Perfect.
And then importantly for patient safety, we need to know what your plan is during, basically up until you do construction, during the construction, and then that transition period afterward. That's kind of where a lot of the sticking is people haven't thought through the process of, oh, I can't do sterile compounding where my roof is missing. Haven't thought through the whole process, and that's why a lot of the waivers that I've been responding to are kind of stagnant because they haven't thought through the fact that, oh, I can't just move my CAI into another room and then OSHPD and CDPH are going to be like, yeah, you can't push that into a patient care room and just assume it's okay. And then I'm like, well, if you want to do that, then you need 2 weeks for process validation because it's a new type of hood, and people aren't thinking through the process. They're just sending in a piece of paper without thought.
So imagine if you took one of the 70 that you've approved.
Yep.
It's a package, correct?
Correct.
They sent you a package, you reviewed
Well, some of those 70, I don't remember how many, the one hospital chain sent me in a spreadsheet with probably 35, and I think probably 30 of those are that 70.
Okay, so
They
again,
did amazing.
so again, imagine if you took 2 or 3 of the 70 that you've approved, blanked out the names, and said, this is what a package, a completed package that went through our process and was approved looks like.
That information out. I'm looking at Laura.
Well, I'm looking at it from so my background is in medical devices, and I know that sometimes they give you templates of what process validation.
Washington, I think that your questions are very specific to one. Maybe you could send an email to the compounding website and Christine can review it with you with your specific pharmacy. But I'm trying to move the meeting along.
I'm good. I was just listening to the discussion.
Perfect.
And I'm trying to tie it all together and saying, you know what, put a package together for people who.
Yep.
Anyway, okay. So
Yeah,
I
I
guess-
think that maybe that would have been a great idea for me to do like 2 months ago. But at this point, I'm so deep in that stopping to do that and then sending it 280 back, it's just going to cause me more wheel spinning.
Okay, yes.
It's a state. We can't be
just-
efficient. Come on.
Thank you.
Sure, thank you.
I have a question. Couldn't we just take a few waivers that were granted, redact the names, and say, here's an application that made it?
We did that at the last meeting. We actually had one that was presented. It actually had the name of the hospital on it, but it was presented at the last meeting.
Yep.
So you can look at that one.
The one in San Jose. There was actually, I think, the 3 waivers we had received at that
So
point.
it's available online for anybody to
Yep,
look
it's on
at?
our website.
Yeah, I think that's still in the meeting material from the meeting in San Jose.
Okay, good.
Good afternoon.
Hi, good afternoon. How are you? I'm Corbin Bennett from Kaiser Permanente. I am our national director for our oncology and outpatient infusion pharmacies. Also spearheaded the waiver process with Doug O'Brien and Don Kaplan from Kaiser Permanente. So I wanted to share a few statistics with you from Kaiser Permanente, but also wanted to start by saying we are absolutely committed to meeting the regulations moving forward as soon as we possibly can. We submitted 59 waivers on December 14th, so if you look at the calendar, 59 of the 60 on that day came from Kaiser Permanente. We did withdraw 2 since then, so we have 57 currently submitted. We have, of those 57, 30 are under the hospital license and 27 under the outpatient license, the PHY. For our hospitals, we average about 1 to 10 hazardous drugs, and we're defining hazardous drugs as NIOSH Table 1 drugs or antineoplastics. In our PHYs, which are our outpatient clinics that service our chemotherapy or oncology patients, we average anywhere from 15 up to 75 per day. So pretty significant numbers on the outpatient side. 2 of our pharmacies we had to close on January 1st because of the type of hood that they're using. So they were in violation of 1751.4. So that has been a significant challenge for 2 of our oncology centers in Northern California. We have been able to move that volume, but it's only day 2, so we're still seeing what the impact on patient care is for that. We're moving as quickly as possible to replace those hoods.
Were you advised by the board to close them down?
No, well, we were advised based on the policy, or I'm sorry, on the CCR 1751.4.
Advised by who?
Which is related to, well, it's in the regulation because of the type of airflow.
It was your interpretation that you would not comply due to the regulation.
That, as well as the certifying company, will no longer certify those hoods based on the new regulations.
Okay.
So,
Just wanted to clarify because I thought advised, I was under the impression that the board had somehow advised you to close down. I just wanted to clarify that.
yeah. So the company that certifies those hoods will no longer certify them. We
Okay.
found out about 1 in October and then 1 just recently in December.
Thank you.
Christine has been very helpful in this entire process, so I want to thank her for that. We have filled out a spreadsheet and submitted that. When we did submit the initial 57, she asked for clarification on 45 of those. And the main concern was the timeline that we had for our remediation. We had a timeline that in some cases went out to 2019. For being able to meet. The 2 most common waiver requests are 1735.6E1, which is related to having a physically separate room, and 1735.6E2, which is related to having negative pressure, so the appropriate negative pressure. So those 2 are our biggest challenges. To be honest, from our perspective, funding is not a concern, even though we will be asking our board of directors for well over $200 million to remediate our pharmacies in California. The bigger concern is really around space. And in some of our older facilities, space is a real concern from the aspect of the licensed pharmacy will not accommodate the template that we've developed for adding a negative pressure room. So that is our biggest challenge. We are exploring all options right now. The mobile clean room was brought up earlier. We have been in contact with a mobile clean room company in Florida. We actually met with them a few times. The challenge is that their business model is they're building based on purchase order. So they will not have a unit available for 16 weeks from the moment that you pay. So they told us the earliest if we decided to submit a purchase order today, that the earliest that they could get us a trailer out from Florida would be in April. So that is a concern, although we are still moving forward with that option. We are looking to purchase. We also looked closely at the modular clean rooms. In many instances, those clean rooms are used throughout the country, but unfortunately in California with OSHPD restrictions and shake test requirements, you don't always they have yet to have pharmacies in California with these modular clean rooms. However, we're still exploring that. In relation to the milestones and the timeline that we've submitted, I'd like to invite up Robin Burr, who's our Executive Director for National Facility Services. She's not a pharmacist, but she is responsible for building and remodeling in 22 of our hospitals in Northern California, and she can speak to a little bit about why our timeline is so drawn out. So I'd like to invite Robin up.
Good afternoon. There'll be a green light down there. Yeah, there you go.
Can you hear me now?
Yes.
Ah, wonderful. Okay, correct. I am not a pharmacist. I'm actually an architect by training, and my job is that I'm responsible for the teams that do design and construction in Northern California, so responsible for all pharmacy construction. And thought it might be useful to explain to you the process that we go through when we're confronted with a challenge like this. So the first thing we do is we scope, and scoping means that we collect all the as-built drawings, we go out and we look at the physical space, the mechanical systems, the requirements of regulatory requirements, and then determine what is the problem we have to solve. And our pharmacies are falling into a few different categories. There are some where we have adequate space, and our HVAC, heating, ventilating, air conditioning equipment can accommodate the additional ventilation needs, and those pharmacies are going to move very quickly because we have space and we have system capacity. We're finding some pharmacies where we have the space to expand into an adjacent area, soft space, but still have air issues and have to make, major changes to our system. We have other pharmacies where we physically don't have a solution for what gives in order to make enough space to build our clean room and reconfigure our pharmacy. So we're having to look at relocating other departments or relocating our pharmacy to get adequate space. So when we turn in a spreadsheet with a waiver request that have dates spanning from 2017 through 2019, it really reflects the whole gamut from the pharmacies where a solution is possible within the space and a pharmacy where it's not solvable in the space as it exists. We are in the scoping process. We don't have documents done yet, and so when we ask for a 2019 date, we're giving a worst case scenario, and our goal is to go much faster if humanly possible. As Corbin noted, 30 of our pharmacies are in 24-hour hospitals, and as you know, when you renovate in a hospital, you disrupt other systems, you disrupt power and water and medical gases and air supply, and so it takes care and it takes time. So really just want to reiterate what Corbin said, that our organization is 100% behind us on the funding for this work, completely ready to go forward as quickly as we can, and our goal is to thoughtfully solve the problem and then go as quickly as we can.
But when did the scoping process start?
We are underway already. All of our pharmacies have been through a cursory survey, and we've released the pharmacies to go into construction documents where the solution was easy. We are in a major funding process right now, and we expect to have full funding in January to really break loose on the more expensive, time-consuming projects. We have gotten RFQs from 5 architectural and engineering firms, and we're in the selection process right now. We'll divide the work among 5 firms so that we don't drown any architectural firm. And our goal is to hit the ground running in February of 2017, so about a month from now, to really start moving things through the gate, bracketing them on complexity, and I think we'll be able to give Christina far better dates 3 to 6 months from now when we have our arms around how challenging problems are, with the goal of beating every date we've submitted.
Board member questions?
Just one thing real quick. The reason why we are starting scoping now, one of our challenges was ensuring that the regulations were finalized, and I know they weren't final until September of 2016. And although they have been, yes, in preparation for the last 3 years, Robin has a lot of different priorities, new emergency rooms, new pediatric units. So the pot of money and, more importantly, space is finite. So we had started work in February of this year with the enactment of USP 800 on February 1st of 2016, but we really didn't get moving until the new regulations were enacted.
I have a question. In regards to the compounding facilities, for example, you have 59 that you submitted and around 40 that are currently pending. Are they still currently allowed to compound during that particular time, or is it just pending approval, or how does that work?
That's Christine's.
Yeah, that's Christine, yeah.
Well, the answer you'll get back from me in writing is the law went into effect on 1/1/17. You either have an approved waiver or you're in compliance. Are we running out and inspecting looking for this? No. But that's my answer. I'm sure Alan's going to jump to counter on me right now. But the law went into effect on 1/1/17. I clearly have a lot of work to go before 300 plus facilities know whether they've got an approved waiver or not.
So technically, they're not allowed to, obviously, as of the first of the year. But since we're backlogged or they're still pending information, they kind of are in limbo right now, correct?
Correct.
Okay, how do we resolve that?
All I can do is continue to process them. I mean, there's not much. Well, you saw the date range in which we received them. I mean, Kaiser alone sent me 59, 14 days before they needed an answer.
So basically, we hold back on enforcement.
Well, what we're doing is educational compliance, which we would normally be doing anyway on this. We're trying to get people into compliance at this stage because some of these things are pretty major. When we walk in, if we see an egregious situation, we can act to do something if we need to, because the underlying core of all this is public protection, which we haven't been talking about. We're talking about compliance, so the goal is to do that. But there are other things that a pharmacy can do. Sometimes if it's a particular type of product, they could buy it from someone else. They could shorten the beyond use date, which is the time it's good for, so that you basically administer the product before it has a chance to grow anything that could injure the patient. So there are some various other things that entities can do, but the goal is to get everybody in compliance as quickly as possible so that we don't have to deal with this, because we don't want to be the next Massachusetts.
Well, part of it's a balancing act too, because
It
if you
is.
also stop, we've noticed some hospitals that are like in rural areas, and if we basically tell them you can't compound, that prevents access to patients. So it's a balancing act, so the only thing we really are looking for when we look at the waivers is a good faith effort being made. I mean, as I stated before, there's one hospital chain that submitted almost all of theirs. I mean, Christine and I have talked about it in the committee meetings, they've gone above board and they've almost all completed, yet there's others that are just submitting it now. So it's a timing issue, and we have had these laws pending for a while. So it would have been good to have these in as soon as possible. Thank you. All right, anything else on a public comment? And we're actually trying to limit these to 5 minutes because we need to get along with the agenda.
I will be short.
Okay.
Sure, I do have a waiver. I just wanted to comment, just so everybody knows. So Jeff Nahira, Director of Pharmacy for Mercy General Hospital in Sacramento. So just to let you know, I mean, we are dedicated for compliance among Dignity Health, and we are in the process of, we're getting the waiver. It's in process, and I'm sure I'll get it as well. But just to let the board know how the beyond use dating is affecting individual hospitals, I think the board should hear it. So as a result of having to go down to a lower beyond use date, we have to process one compound at a time pretty much for a center that usually compounds multiple medications at once amongst different hoods. So that has been a challenge. This has quadrupled, if not quintupled, our workload on the pharmacy. And so I just want the board to know that we are making considerations. But there is also a concern as well. I mean, the board has done a great job in terms of getting their inspectors on the same page. I think there's a little bit of discrepancy amongst, not necessarily board inspectors, but some other regulatory agencies as well, what constitutes the need for lower beyond use dating. For the board, it's having, like right now I have barrier isolators. I do have that in an IV room, which was allowable prior to USB 7, the new USB 797 coming out, but I've had to go to 12-hour beyond use dating from other regulatory bodies because they did not recognize viable sampling as being separate from the ISO requirement. Viable sampling, by the way, is something that you need to have in order to test the validity of your processes, but doesn't have an effect on the ISO requirement of the hood as well. So that has been a challenge of getting that consistent among the regulatory agencies or with the inspectors as well. I just wanted to comment that to the board, and I do thank you for your time, and thank you a lot, Christine, for your...
Thank you. Thank you. Yes, good afternoon.
I am Renelle Larson. I'm a compounding pharmacist. in California. And I wanted to tag onto Ms. Muniz's point. A lot of pharmacies are got the auto reject response, or not auto reject, but the auto response from the email saying, and that I believe it was, correct me if I'm wrong, the date's 12/14. They won't be processed until 1/15 or after 1/15.
The
was
waiver
exact verbiage?
email?
Yes.
On the 15th, because of the volume that was coming in, I had to put a cutoff. So as of the 15th, the email that you get says your waiver request was received.
Right.
And it will be processed sometime in January.
Right, and the date that I've seen was
I think
January
it's- yeah,
15th.
I've processed the ones we've received through the 14th or the 15th. I can
Okay.
look.
Well, my concern is obviously January 15th, it's a Sunday. Then you have Martin Luther King Day, which is that 16th, which is the Monday. And then you have this little one over here that's totally overloaded and doing a great job. But these pharmacies are not going to be they're going to be stuck in this gray area. Nobody wants a gray area. I don't think the pharmacists want a gray area. And then the Board of Pharmacy doesn't want them to be stuck in a gray area. They want to follow the laws. So 1/117, technically they need to either have a waiver or be in compliance. So what are they to do when they have patients and I'm not talking about necessarily sterile compounding. This is non-sterile compounding where they have women's hormones, methimazole for cats, stuff that will really pose a detriment to patients if they are without their medications. And so it is of concern to me and to my fellow pharmacists that I've been communicating with that what do? They don't want to go against the board, but they have this obligation. They've signed an oath, and they've said this oath as a pharmacist to protect their patients. So what do we do? They're all worried about the the Board of Pharmacy going back and saying, well, what did you do during these X number of days that you weren't in compliance? They've submitted a waiver. So I'm talking about the people who have submitted a waiver. They've submitted a waiver. It's not approved or denied yet. How do they compound?
They should probably keep a copy of their waivers. What I recommend pharmacies, keep a copy in your pharmacy. If you become inspected, you can show them that waiver, say, I'm waiting to hear from the Board of Pharmacy. I don't know, Christine, if you've got any other recommendations.
It's just going to be a process. When we get 200 that are expecting a response and over a holiday in 15 days, it's just going to be a process. We're not sending staff out looking for specific things at this point. Like Jenny just said, it's educational at this point. The inspections that have already been conducted this week in and out of state have been corrections and education only. With the exception of one pharmacy. That's the only one I know we've given a violation on this whole week. I can't give approval or an okay to violate the law. I'm mandated to protect the public, and the laws are what I uphold.
So the pharmacy basically has to kind of chance it, that they're going to be okay.
I can't answer that question for you. Like I said, it's either you have an approved waiver or you guys are in compliance. So I don't know if Jenny wants to provide additional information on that, but I don't have an answer for you.
I think that there's a deliberative process that we need to be very careful with in terms of how we're proceeding with the waivers. And they're actually starting to sort, those of us that are doing this, we're actually seeing them sorted to various buckets.
Okay.
And so the goal is to help you provide the information we need. We don't want to give you the answers that if you say it this way, it'll get through, because that may or may not work for you. And in fact, for public safety, that isn't a good way to go. We want you to really work through what it's going to take for you to become compliant, what's reasonable, and what a reasonable timeline is. And we'll get to it as soon as we can. The more complete the responses that comes in, the less likely it's going to be to bounce back and forth. Of the ones we reviewed yesterday, we bounced, I don't know how many, maybe 15, 20?
I think yesterday at the meeting, and they're not represented.
And I left before you were done.
Yeah, we're not represented in this data. I think we probably, of the 214, we probably approved another 35 or 40 of them, but I sent an additional 10 or 15 emails. I still have some more that I have to respond to. So,
Spend the extra 30 minutes to really delve into what you're doing, because you are really committing where you're going with the pharmacy on this.
I completely understand, and I 100% agree with you. My concern is for these pharmacists that are stuck in this area that, we've submitted a waiver, whether it was, December 31st, but they want to do it right, but they also are afraid that if the board's going to come back and say, well, you technically weren't in compliance during these days and we're going to fine you. I think that that's the big issue that they're concerned about.
But the very thing that you're going to defer during the period that you're seeking, that the waiver is going to be in effect to permit you to construct, is the very thing you could start now.
Right, so there's a provision on there, I believe it's section 3 on the waiver that says how would you compound during construction. So if they were to put those in place and compound during those.
I would say do that now because that's part of your plan.
Right, so they can do that now and they should be
Right.
safe from any type of ramifications, should they be following that to the T.
You're never going to get a
I know, I'm
blanket
trying to
waiver.
get
When
you
you
to
say
say-
waiver, you're never going to get a blanket waiver like that out of the board. Again, but that's not that we're trying to be difficult. We literally, in the area of compounding, and particularly sterile compounding, we've got a serious public trust mandate that we
I
have to ensure we meet first and foremost, which is our mandate. So.
And I don't want to argue that at all.
No, I don't see that it's an argument, but,
Yeah.
but again, what you put in that one column, though, is kind of your way through for the next 18 months.
Right.
So.
It's a good faith effort to
That's
follow what they
you've
said
already
they put
done
out.
it. By doing the hard work, you've already kind of identified how you're going to proceed.
Right. Great, thank you.
Thank you. Any other public comment?
Hi, Jenny Partridge, and I'm going to kind of look at you on this one. I think this might be helpful for some of the folks. Renell mentioned hormones and methimazole. Those are not Table 1 anti-neoplastics. They do not need to be vented out. You do not need to vent the hood out. If you follow USP Chapter 800 and you follow California law, you just need to do an assessment of risk, a very thorough assessment of risk. There are a number of forms out there, and if you follow that, then you don't need to bombard Christine with waivers. You can't do Table 1 anti-neoplastics, but the majority of our compounders are doing Table 2 and 3. And so I just wanted to.
Especially non-sterile.
To bring that up.
Yeah.
Yes, thank you for clarifying, non-sterile.
Yes. Thank you. Any other public comment? Okay, otherwise we'll move on to item C, which is the GAO. In mid-November 2016, GAO released a report on the regulation of compounding by states following the 2012 New England Compounding Center public health emergency. Below is the executive summary of the 70-page report, which is in attachment 10. What the GAO found, basically, I think you can read the summary in the packet, but one of the things, and I actually saw this as well when I was at the ASHP meeting when we met with the boards, other boards of pharmacy, the pharmacists that run the boards of pharmacy, is that there's other states that are now going into looking at sterile compounding in non-pharmacy areas. So looking at physicians' offices and areas where sterile compounding is performed, but the Board of Pharmacy doesn't have any oversight. So the actual regulations that have come out actually do, at least from the federal level, cover as well the physician offices and compounding by non-pharmacists. So FDA has taken steps to implement regulatory responsibilities, and they've issued numerous draft and final guidance documents. So I think this is just for information purposes.
Yep, that's all it was.
Any board member comments? Any public comments? Good afternoon, Tony.
Hi there, Tony Park. So one thing that I picked up on the GAO report that I'm not sure if the board is aware of is that according to the GAO, a 503B outsourcing facility can honor not only the office use and the institutional type, non-patient-specific prescription, but there's a heavy insinuation that they can also take on patient-specific prescriptions. So I just want to make sure that the pending licensure process that the board has in place for the outsourcing facility also contemplates essentially the practice of pharmacy, potentially the practice of pharmacy within a 503B outsourcing facility.
No. Our statute specifically allocates outsourcing facility to the equivalent of a manufacturing type compounding operation. The board, at the time the legislation went through, took the position that the services provided by a pharmacy with respect to consultation, patient-specific services, and the overview and the time spent would be lost in an outsourcer. And so the statute that enacts the board's outsourcing provisions specifically state that it shall not be a pharmacy. So if you have a specialty outsourcer that that produces a particular product that would benefit, for example, me, that product would have to go to a pharmacy or to a prescriber's office to have it specifically labeled and dispensed to me. Okay?
Thank you.
Did that answer your question?
Yes, thank you very much.
Okay, yeah. A lot of states are in the same direction, and I believe the FDA is even rethinking whether or not it wants outsourcers to compound for patient-specific.
Thank you. So item D, review and discussion of California law governing compounding and conflicts with USP Section 800. Now that our sterile compounding regulations are on the books, it's been 3 years in the making, USP 800 has also come out and been finalized. We had asked Christine to go over USP 800 versus our regulations to ensure that there wasn't any updates that we needed to have, maybe something we overlooked that we needed to basically reconcile with USP 800. So Christine.
I'm sure people are going to have a lot more, so I put more seats. The biggest
Is that what you were doing?
Just, getting my circulation going. The biggest thing that every time I review 800 versus our reg that keeps coming up is the allowance for the double HIPAA filters for the non-sterile hazardous. I've reviewed several articles that you provided, and I have different opinions about doing it, whether we would want to add it in or not. But that's the big thing that conflicts between our now enacted regulations and USP 800 in my mind. That's the biggest difference that we have, besides if we wanted to readdress how we defined some things. There's some issues with how we defined like a biological safety cabinet versus how it's defined elsewhere. And then should probably have Jenny come up here. She gave me lots of good ideas. And then also the option of some other conflicts that we have in our regulations that were not enacted in 1735. There's an issue with Business and Professions Code 4127.7 as it relates to some Title 24 building codes. So you want me to read you those specifics, or you want to start with the 800 specific differences?
Let's start with the 800 ones
Okay.
to see.
So to me, it's the biggest one is the double HIPAA filter in series that's allowed. It's not currently allowed under our new regulations. Adding it would make us more consistent with the federal, but the concern is that when I talk to the facility certification people, they don't really have a standard necessarily in the CETA certification for double HIPAA filters, how to certify the two. Right now, their thinking is that it'll be a HIPAA filter, some kind of gap, another HIPAA filter, but when you can't reach both sides of a HIPAA filter, you can't certify a HIPAA filter correctly. So they're not sure how much benefit you would get in a double HIPAA filter in series. So I'm kind of about that one, but the idea of it's a double HIPAA filter in series in the Class 1 biological safety cabinet, which is in an externally vented, negative pressure room with, at least 12 layer changes. It's externally vented anyways. So I'm not sure that having the PEC or the biological safety cabinet also vented gets us much more. But so I'm kind of torn. So it's kind of up to you whether you would want to add that in or not.
And I know we'd heard from some compounding pharmacies in previous board meetings about the desire to use the double filtration
Correct.
system, so it would be easier for them. And this is in non-sterile compounding.
Correct. It would only be allowable in a Class 1, so basically a powder hood for mixing creams.
So why not just leave ours in place?
I think some of the fact of having to vent outside created an issue for some of the non-sterile compounders. At least we heard that as comments. I don't know if any of them are in the room that can speak to that.
But I thought you were talking about the double filter.
I'm talking, well,
In lieu of venting.
no, it'd be in lieu of venting the PEC. It'd be
PEC,
in lieu
right.
of venting the hood that's used,
Right.
but I don't think
Correct.
that we can change the requirement to vent the room. We
Right.
would still have the venting of the room, but do we want to change and allow HIPAA filters for the actual unit use?
Right.
So we'll hear from some of the people that are impacted.
Good afternoon. My name is Rick Rhodes. With University Compounding Pharmacy, I can speak to that issue. We've been working diligently to do construction on our facility, and one of the issues that we ran into was the HVAC requirements. The demands of the HVAC go up almost exponentially when you have to vent out the PEC, the hood. In our case, we have almost a dozen of these hoods, and there's a significant amount of air that needs to leave the room for I don't have the actual knowledge or the lingo down for HVAC, but there's a tremendous amount of air. You have to replace that air back in the room. In some cases, our HVAC contractor said you have to have an AC the size of one parking space. I mean, the demands went up tremendously. And so when you add that double HEPA filter, it prevents those complications from it's much more difficult to do.
And the fact that it's just an option, and the fact that USP 800 allows it, we thought it would be good to have that.
So we
don't have that as an allowance. They have to vent it in ours.
So
No, excuse me. Venting out is more difficult to do. No, actually, when you vent out the hood, instead of the air going through a double HEPA filter and then staying in the room, all of that air has to now leave the room. So you have to replace
option.
that.
So we would be more accountable.
Yes.
Yes, sir.
Yeah.
Yes.
So they have an option, either vent or do the double HEPA filter, and you're in favor of the double HEPA filter.
Yes, ma'am. Yes.
Any other public comment?
Compounding pharmacy. Also keep in mind that 800 USP, these people are experts, and they've taken information from tens of thousands of people and commented on this, and they've already went through it, and they believe that double filtration is acceptable for level 2 and 3, where level 1 is antineoplastics, and you're doing the right way according to USP. I think we just missed that part when we wrote the law.
Thank you. John?
Good afternoon, John Roth, CPHA. We too would support consistency with USP 800 in this regard, allowing for the double filtration system as an option for non-sterile compounding. I think it just provides an option that our members are asking for.
Thank you. Get a motion to
I'll make the motion.
have staff. Any other public comment?
Before you go to public comment, I just want to clarify, are there other provisions within USP 800 that you would be making amendments to, or are we focusing?
I thought that's the only one I heard from 800.
That's why I'm asking the question.
The other one I would probably suggest is slightly editing the definition that we have of biological safety cabinet because of how we used it. The definition of 1735.1C actually limits a biological safety cabinet to sterile drug preparation, and we need to broaden the scope of it because a biological safety cabinet can be used for non-sterile as well. So my suggestion would, the easy way, would probably be just to remove in 1735.1 the term sterile drug preparation. Yeah. Haven't gotten there yet.
Maybe what we could we maybe have just drafts of the language with the strikeout and bring it back so that we can at least see it? That would probably be a lot easier.
With all the pending waivers, if we're going to allow the HEPA filter, I'd rather move that one. I mean, the definition, we can play with.
Let's just leave, let that one go.
So what the double HEPA filter, I can't even talk, double HEPA filter is 1735.6. The issue that we have that conflicts with CGMPs and 800 is 4127. So that's a compound issue. These are the easy issues.
If we can move this one and then we can get the board to approve it at the end of January and we can move it into rulemaking, we can at least help you with the waivers on that.
Okay, that's what I'm thinking, because that will help some of our non-sterile compounders significantly. But can we look at the definition?
Yes.
Can we look at the definition of biological safety cabinets? I think just removing the word sterile from it broadens it, because what we kind of did is limit ourselves.
Is it okay to add that one to your motion, Stan?
I'm very flexible.
Greg, you okay with second on that one?
Okay, I'll bring that to Jenny.
Are there any others? Does it, the only two urgent ones?
So the motion on the table is to bring into compliance or to mirror the provisions of USP 800 as to the double HEPA filter, as well as the definition of biological safety cabinet. Okay.
Removing the word sterile. That's an easy one.
Just because we required external venting of a biological safety cabinet, and then we defined it as only sterile. Oops.
Any public comment on the motion?
No, I don't like that. She had another
Okay.
suggestion, but I don't agree with it.
All in favor? Okay. Motion passes. Okay, thanks.
The only recommendation I would have going forward is if you would bring the language that you feel that we should deal with at our at our next enforcement meeting. Do we have
Yes.
time to do it at the enforcement meeting and then bring it to the board?
Yes.
And then that would expedite the whole thing.
Except for, no, these two we're going to move forward. I think he means that any future ones.
Yeah.
That's fine. Yeah, no
Great.
problem.
Is there any other urgent ones that you need?
No, I want to talk about one more, but I don't think it's as urgent because it's a business profession code. I think it's going to take a little bit longer. Oh, right. So, figure out what we want to go. Okay, so the other bigger issue is USP 800 is going, well, and our new regulations are going to conflict with Business Professions Code 4127.7, which basically states that any injectable from non-sterile ingredients are required to be compounded in ISO 5 laminar flow hood within an ISO Class 8 clean room, and it must have positive pressure. That's a direct conflict with USP 800. If it's a hazardous drug, it must be negative. It's also direct conflict with 1735. It also conflicts with CGMPs, so we've heard from the FDA. We have incorporated this also because 4127.7 is actually a direct cut and paste from Title 24. So 1250.4 is actually the building code that requires that. So my suggestion is going to be, and I don't know how we do this or what the actual term is, to remove 4127.7, and then in the references that we use it in 1751, because we require in 1751B3, we incorporated 1250.4 by reference. If we can just limit the 1250.4 to the subsections 1 through 3, then it eliminates the building code section that's no longer valid. And I can bring you all that in writing.
Please.
I don't personally see that we get anything out of that except for more verbiage for what we already have under 1751.
Okay.
It's all requirements for compounding room, and I feel like it's much simpler in 51.
So as part of the recommendation is to remove 4127.7, which is a reg.
Correct.
No, that's statute.
Statute, sorry.
And the changes we have to make to the reg,
4127?
we can do later. Yeah, 4127 is a
Okay.
statutory, that's in the BMP
So
code.
you've got an author.
Yeah, well, an author has come forward seeking to provide us with this assistance, so I would suggest we not turn that down.
Need a motion?
Yes, we do.
Anyone?
It's still got to go to the board, but.
Alan? Greg?
Are you guys are eyeballing each other.
Okay, the recommendation, the recommendation is to recommend to the board to repeal 4127.7 because of the conflict with USP.
Was that
800.
Greg issuing it?
Greg, and it's second?
I'll second.
Oh, the duo, dynamic duo. Second, any public comment? All in favor? Okay. And then the others, maybe you can bring them to the next enforcement committee with strikeouts
Or
so that
bring
we
them
can
to the
review
board.
them.
If we bring them to the board, that way we can move the reg hearing at the board.
I'll get them to Jenny by the end of the week, and then she can
Okay.
get them where they need to be.
Any that are not, are these urgent? The other ones?
Those are the three issues that come across my desk a lot. There are a few
I'll help
other
with the
little
waivers,
things, but
too.
I want to work them out a little bit, but those are the
Yeah, I
three
think
that
the
I'm
rest,
doing.
the others, the three we can move them to the board, but then if she has any others, just bring us the strikeouts
Yeah, and
with
we
the
may just have an
language.
ongoing thing, yeah.
Okay.
Yeah.
Okay, great, all right. Item E, presentation on requirements for sterile compounding master formulas. One of the things I noted in Alan's presentation was that the master compounding formula is a frequent area of citation. So I think there's some confusion on what exactly is required. So I had asked Christine to see if she can just give us an overview of what the master compounding formula requirements are. What are some samples of ones that have worked, so that everyone's on the same page with what the requirements are. Because I really want to see if we can educate rather than play I gotcha with the citations.
So this is the requirements for a master formula at 1735.2E. Basically, this is the exact same requirements it was 2 weeks ago as it is today. This actually hasn't changed since, I believe, 2010 or even 2013. One of those was the original one. We are asking and requiring that no drug be prepared until the pharmacy has first prepared a written, key, it must be written in some written form, formula that includes at least the following elements: active ingredients, equipment, maximal allowable BUD, and the rationale or reference source for justifying the determination, inactive ingredients to be used, specific and essential compounding steps, quality reviews, post-compounding process and procedures, if any, instructions for storage, handling of the compounded drug products. So the biggest question I get right now is, what is rationale or reference source? Well, how did you figure out that that's the BUD you can allow? Tell me how you figured it out. If you figured it out by looking at our regulations, then reference 1735. That's fine. If you got it from USP 797, reference USP 797. You have to have some rationale. Many people have years and years of experience, and that does play a role, but we are an evidence-based practice. We need evidence-based research. So give me some written document where somebody's done some actual legwork on your product. This is what we're looking for when we look for your master formula. We're looking for it to match actually what you did in your compounding log. All right. Oh, darn. You guys can't see it very well. Okay. So what I did is I actually made a couple. It may be easier for me to make this bigger for you, but what you can actually see is the name up here of the drug. It talks about exactly what it is, and then here are the ingredients. The active ingredient, we're making drug today. The inactive ingredient or the diluent, the equipment that's being used. In this case, it calls out the exact isolate they're using, and they use a metal tray. And then you go down and you look at the supplies. And then you're going to look at the different garb that's going to be needed. And then there is an extensive amount of procedural stuff that they're going to use. And then an assigned BUD. And you look right here, it says under refrigeration. So that's going to qualify basically for everything that's required in a master formula. The only thing that when I reviewed this one that I really wanted is I wanted a little bit more of how it was actually labeled. A lot of times what we see, and in the next example, you'll actually see where people will take the label that they slip on the product and they stick it on the batch record or on the master formula, so you can see actually what they're expecting. So under refrigeration, we'll get a little blue sticker that says refrigerate. Or they'll say something to that effect. And then you'll also see, instead of dispose waste and sharps accordingly, you'll see put sharps into red sharps container, dispose of all waste, depending. I mean, if it's a chemotherapy, it'll say bulk waste container. Something to that effect. But if you look at the amount of steps that are in here, anybody that comes in can, breaking stuff, can come in and make this product. So when we look at a master formula, I shouldn't need anybody to explain to me what you did unless I don't know how to use one of your pieces of equipment. I should be able to come in and be like, okay, here's what I need to do. Okay, step 1, complete the compounding record. Okay, where's your compounding record? And then you do it. The pharmacist must initial the quality reviews. Okay, I know a pharmacist has to do that. Okay, if my isolator was off, then I have to turn it on for 10 minutes. Great, good to know. Wipe down all the materials. It would have been nice to know how we wipe them down, but assumably there was sufficient training for somebody, so that would be something that the staff would already know how to do. Wait at least 1 minute for the purge time for the antechamber. Extremely important, because if we're going to use a CAI and try to get extended BUDs, one of the things we have to know is the exact time it takes for that unit to purge before it's back to the ISO 5 and you can continue to compound. Very important. I like that that was in this master formula. And as you go down here, if you read this, and I'm really sorry, I thought it would be bigger, you will see that it's very, very specific. I don't have to ask questions when I get this master formula, and a person, after you've given them training, can compound this product. That's what we want to see in a master formula. And if you look at their references, they're really not all that exciting, but they're giving a 14-day BUD on a sterile-to-sterile product, so it's within compliance of Trissels tends to give just stability data, fine, so we know that it's stable. 14 days is within, depending on their unit, assumably they have a properly certified CAI, because we know it's an isolator. So they can give a 14-day, and I'm not going to question it under refrigeration. Don't have any issues with this particular master formula. I thought it looked really nice. Now let's move on to the other ones. All right. So this is something, and if you actually see a drug or a name, I'm sorry, I tried to block them all out. This is something that we see quite frequently. It's a software that's used, and I really like this software when it's used appropriately. It will catch a lot of things, but we see it used very inappropriately a lot of the time. So here you'll have all the pharmacy information. You'll have the drug information here. You have all of the dates you could possibly need. This doubles as a master formula and a compounding log because it meets all of the requirements. When we ask for a master formula, they tend to be able to print this out without all of these items filled in. It will be blank because these are requirements of the compounding log, but all of this lovely stuff right here will be filled in, so it tells us exactly what we're doing. Only thing on this one I would like to see, and it's kind of hard, is it says send samples to analytical for testing. To me, if it was doubling as a compounding log and a master formula, I would like to see how many samples they sent. But since we're just discussing master formulas, it's acceptable for a master formula. But if it was doubling as a compounding log, I would ask them, well, how many samples did you send? Because if you're making a batch of 4,500 mLs, what's our volume size? I would probably expect a decent number for them to be going out. I don't see, yeah, so we got store at room temperature. So this one, again, meets the requirements of master formula. It has everything they have to do. It even has autoclave temperature, which would be that post-compounding process. And again, compliant master formula, this one usually doubles also as the compounding log. As you can see, I just grabbed this from somebody. They actually hand wrote it in, which is fine as well. Here's the last one. Just pretend the drug name's not on there. All right, this is another one. I plucked them all out but one. I saw it this morning. This is another one that's just master formula. Up here talks about the drug that's being made, and then the drug, and then the quantities, and then it has all the suggested procedures. This one actually comes with different notes. Why is it jumping everywhere? The bottom line is there's many, many different master formulas. And it doesn't really matter the order you put them in, as long as they're all on there and you have some type of reference is the biggest new thing. Is there particular questions on the master formula?
No, can we post, I think I asked Jenny, could we post on the website your presentation as well as readable copies of these attachments so that we can at least see some, and they're just samples is all they are.
Yeah, I need to edit a little bit more. But
yeah, if you can edit and take out any information, but at least they'd be readable and we can use those as reference.
Yeah, that's fine. I think there's a lot of, PCCA has a lot of master formulas, and 99% of the time there is no issues with them. Mediska has them, Spectrum has them. There are a lot of very compliant master formulas that have everything that we would find and that we would need. The biggest problem, and the reason why you keep having them, is people tend to deviate from their master formula and they don't go back and do something else. So the first one that I showed you guys was the PCA one. So they'll try to use the PCA one and they will use a different drug. This PCA one, they'll use a completely different drug and they won't change the master formula. The process may still be the same, but we need a master formula for every drug you're making. or they think that because it was electronically stored at a company, that when they go back 3 years later, that same master formula is still going to be stored at the company, and the company no longer uses that when they've updated it to version 2. And so then they don't have a master formula for what they've been doing for the last year. So we still see a lot of that.
Thanks, Christine. Any board member comments, public comments?
Just a comment about collating the,
Not required anymore.
no, just to make sure that we can bring it all up electronically, and I think it's clear. There was one little problem that we really need to discuss.
Okay.
Is the beyond use date. Clearly, it's stated there, if you have some information, tristles, this and that, that's good. But the law says that you must do a stability test, a method suitability test, a container closure test. All this has to be done. And I'm not sure when this law was written. I think she's correct, and that's the way it should be. That's the way it's across the United States. But I think what we did is wrote in GMP stability lab testing. And I'm not sure if you're aware of this. That's the exact same thing Pfizer's got to do. And that's what we have to do for all of our sterile products and non-sterile. So just to give you a rough idea, I have each sterile injection is $30,000. One injection I got is $90,000. Every progesterone, every hormone that's in stock solution, stocks, because we make stocks and we make cuts from that, those all have to be tested because it has to be done in the container stability testing. Then if you mix one with another, there's another stability test and another. You're looking at somewhere in the range of $8,000 per drug. Now, I'm just doing the fast movers because the law says this, and I'm doing it. It's $750,000. And I'm telling you, I don't think these people are going to do this. So that means that if you don't do this now, incidentally, according to the law, you have to start compounding from scratch.
I'm not sure this is on our agenda, because we're talking about the master compounding, and you're talking about stability testing.
But that was part of the BUD.
Yeah, but I want to make sure we make sure we stay on the agenda
Okay.
per our attorney, because we've had a lot of other agenda items discussing that before. But it would be something, I'm sure Christine heard you, and we can take a look at it.
I know where you are.
All right, any other public comment?
Yeah, I understand.
Okay, going on to item F, discussion and consideration of the proposed FDA list of bulk drug substances that can be used to compound drug products. On December 16th, the FDA proposed a rule which lists the bulk drug substances can be used to compound drug products. Can we send this out as this isn't final though, this is just draft for comment?
They're asking for comments on the, I believe there's 10 products that they're adding. 6 they said that are bulks, appropriate for bulks. 4 that they say are inappropriate for bulks and you cannot use them. And we're not compounders, and I don't think we have any particular expertise in here. Do you have comments? Oh, Christine's got comments apparently.
So I've been kind of following what the FDA's been doing, and what they're basically doing is developing for 503A and 503B, they're developing categories. Category 1 are drug, like API, so drug powders that you're allowed to use. Drug 2, it's kind of questionable, or Category 2 is questionable, and Category 3, they're basically saying there's not enough data. There's actually on their website documents that show what they are, and this is just their newest rendition of adding or taking some off.
Anything on there that concerns you that we need to bring comments up with?
The particular ones that they did this time, no, but I have been following it, and I'm not sure if we want to add this to another agenda item or if we can fit it in here, but I kind of want to follow FDA's suit and say if it's on Category 1, we're okay with compounding. If it's
Let's
on,
put it on the agenda
Yeah,
item, because I
Category
don't think
2,
that's
3.
one of that's on the agenda, maybe the next enforcement committee, compounding, to talk about the FDA guidance categories.
This is a proposed rulemaking, and I don't know when your next committee meeting is, so if you did want to.
Oh, I don't think she doesn't have an issue with this one.
It's a process,
Oh,
it's
I'm
not the
sorry.
list, it's not this list.
She's talking about the process, not
It's
this
the
particular
I'm sorry, I
rulemaking.
misunderstood that. Yeah.
The drug that we talked about not too long ago, and I'm not sure, but it's a compound drug that some pharmacies have been compounding.
Domperidone.
What is it?
Domperidone.
That's it.
It's category 2 for.
So would that be, is that part of what we're talking about right now?
It is on both lists. It's under the category 2 for a 503.
Okay, so going forward, will that eliminate the problems that some pharmacists are encountering by using it in compounded preparations for human consumption?
Loaded question, because it may solve the domperidone problem, but it may cause a lot of other problems. So that's why I think it's a.
I think we need to have a discussion
I think
on
it's a
this.
discussion.
It's probably a bigger issue.
I like the fact that they made a list and that they're using their expertise to say this is a good powder, this is a bad powder, because I don't want to touch that. But I have great concerns if we just blindly adopt them. And
Was that list in here with that drug?
in
my packet?
The bulk list, the
bulk list
6
is one
that
of the
they're
links.
proposing is in the guidance,
Yeah.
but not domperidone.
Okay.
Yeah. So
That's why we just want to just have a whole discussion on the topic.
Okay.
And put it on the
I'm
next
cool.
meeting
I couldn't
agenda.
recall the name, and I knew that
Yeah.
Alan knew it.
All
And
right,
I'm glad
thank
that
you.
you know it as well.
Any public comment? Okay, enforcement statistics are in your attachment. And are there an attachment, right at the very end, I can't see the attachment number. Any board member comments regarding the enforcement statistics?
Also, we provided revised ones where we incorporated in some of the other elements.
Oh, perfect, okay. And it's available now on the website, we can update it?
It was added as additional materials, I believe.
Okay. Okay, great. Any public comment on the board on the enforcement statistics? Meeting dates for 2017, April 18th, July 12th, and October 17th of this year. Meeting adjourned.